Hey, good afternoon, folks, and welcome to the Museum of Natural History. I'm Luke Swetland, the President and CEO. Really want to thank you for attending today's Lunch and Learn webinar. Our topic is planning for peace of mind. Do I need a fiduciary? Today's talk will specifically focus on why you might need a fiduciary and the ways to incorporate that individual into your estate planning on the front side. Before we start, I want to take a moment to reflect upon the loss of our dear friend and colleague, Rochelle Rose, who passed away peacefully last week after several weeks of uncertainty. Rochelle, as many of you know, was our plan giving officer and did so much during her many years here to strengthen the bonds of affection between the museum and many of you. We will always remember her. And now onward, just as Rochelle would have wanted it. So first, a little housekeeping. We emailed you the agenda and the contact information for our speakers if you have any follow-up questions after the program. We will have an opportunity for questions at the end, so please enter any of your questions at any time into the chat function on the bottom of your screen, and we'll get to them. We'll get to as many of them as we can. I want to thank Sarah Clement, our development associate, who is our chat boss for today. She's keeping us all hung together here for this hour. And finally, keep in mind, folks, our speakers are not attorneys, so they can't necessarily respond to a highly personal or complex legal question. If you don't have an attorney and would like a local referral, please contact us. We do have a list of attorneys. Now, I'm delighted to turn this over to Denise Stevens, the president of the museum's Plan Giving Advisory Council. She's also a member of our Mission Creek Legacy Society, and she's going to tell us a bit more about our speakers. Denise?
Hello, everyone. I am really delighted to introduce our panel of experts today. We are very fortunate to have them here with us. Suzi Schomer is the Senior VP in Wealth Management at Montecito Bank. She earned both her bachelor's and master's degree from the University of Southern California and has over 35 years of experience in financial services with expertise in trust and investment management. Her experience includes the development and implementation of wealth management strategies for complex trust, investment, nonprofit, and private banking clients. Suzi's also been an active volunteer in our area for over 2 decades, including serving as either a board member or advisory board member for Visiting Nurse, the Santa Barbara Maritime Museum, the Wildling Museum, and Santa Barbara City College Foundation. She also serves on the Plan Giving Committee for the United Way of Santa Barbara County, VNA Health, Hospice of Santa Barbara, the Santa Barbara Museum of Natural History, yay, and the Music Academy of the West. She previously served as trustee of the Santa Barbara County Employees Retirement System and was treasurer of the Santa Barbara Cemetery Association. Her colleague, Michelle Shipp, is a VP and Senior Trust Officer with Montecito Bank. Michelle has a BA in Political Science and a minor in music from the University of San Diego. She earned her Juris Doctor from Santa Clara University School of Law and also has a personal financial planning certificate from UCSB. She brings 16 years of experience in wealth management in the areas of trust and estate planning, fiduciary services, charitable giving, tax and investment advisory services as well. Michelle is a member of the California Bar Association, the American Bankers Association, California Society of Certified Public Accountants, the Santa Barbara County Bar Association, and the Estate Planning Council and Charitable Gift Planners Group. We also have Jackie Quinn with us today, owner and president of Quinn Fiduciary Services right here in Santa Barbara. She is a California licensed professional fiduciary and acts as a conservator, trustee, administrator, executor, and representative payee. She received her BA in business administration and psychology from Antioch University, later receiving her doctorate in psychology from Saybrook Graduate School and Research Institute. With over 30 years in the estate planning and administration field, she served as past president of the Santa Barbara Estate Planning Council and as a former member of the Santa Barbara Paralegal Association. She's also a former member of the Santa Barbara County Financial Abuse Specialist Team and the Elder Dependent Adult Abuse Prevention Council of Santa Barbara County. Hope I got all that right, Jackie. She's currently a member of the Professional Fiduciary Association of California and the Planned Giving Advisory Council for the Museum of Natural History, and frequently speaks on topics related to the care and safety of elders, legal capacity, and end-of-life decisions. As Luke said, we want to drill down a little bit more on the subject of fiduciaries today. When it comes to organizing your estate plan, who have you named to make sure your wishes are actually carried out? A fiduciary can be a friend, a relative, a licensed professional, or a corporate trustee. Our panelists will talk more about the specific roles of a fiduciary, the skills that are beneficial to those roles, how to go about naming a fiduciary in your plan, and other important considerations. So I'd like to turn this over, and let's start with Suzi Schomer. Thanks.
Thank you. Welcome, everyone, and good afternoon. I thought we should start with a definition of what a fiduciary is. A fiduciary is a person or entity that holds a legal or ethical relationship of trust for the sole benefit of another person. Fiduciaries might be individuals who are family members or friends, a licensed private fiduciary such as Jackie, or a corporate trustee, which is generally a bank. And Michelle, my colleague, will be commenting on that. The selection of a fiduciary is a very important part of estate planning. The fiduciary might be needed to act during a person's lifetime, or should he or she become incapacitated, or only upon death. What is capacity? In order for a person to appoint a fiduciary during lifetime, or to name an executor in a will, or as successor trustee of a trust, he or she must have the legal capacity to do so. The standard of capacity varies depending upon the nature and level of responsibility to be assigned. As Luke mentioned, we do not give legal or tax advice, but we are sharing information as a resource. The legal capacity to create a will or trust or change the terms or beneficiaries of these documents may have a different legal standard than appointing an individual or a private fiduciary as an agent under a financial power of attorney or a healthcare power of attorney. Jackie will comment on these. Our presentation is not designed to provide legal or tax advice, but to provide information and resources. Our discussion today does not address recent requirements that financial advisors must take a fiduciary approach to serving their clients. Today, we're talking about legal documents that name an individual, private fiduciary, or corporate trustee as a fiduciary, either during lifetime or after death. The role of a fiduciary is a complex legal responsibility with a duty to serve in the best interest of the person whose life and assets are to be managed for their benefit. There must be no conflict of interest, undue influence, or lapse of judgment when serving as a fiduciary. The selection of a fiduciary is a serious matter and requires careful thought and evaluation of the options available. Key qualifications are knowledge, experience, and expertise. Just as important are the willingness and availability of an individual to serve as a fiduciary. It is an honor to be named as a fiduciary, but depending upon the personal and family circumstances of the grantor or trustor, it might not be a favor. Ideally, family members will still get together for holidays and special occasions. Sometimes having a neutral professional serving as a fiduciary is the best way to preserve family harmony. Even young, healthy individuals need to consider the importance of choosing an individual, private fiduciary, or corporate trustee who might need to step in should he or she become incapacitated or in the event of death. In Santa Barbara, we should be particularly attentive to the need for a fiduciary after the Thomas Fire, debris flow, to say nothing of the COVID-19 pandemic. Any individual 18 or older must have a power of attorney for healthcare if he or she should need to be admitted to a hospital for treatment. Parents do not have any legal authority to make healthcare decisions for their offspring 18 or older. Corporate trustees can serve in any state, but might need to select an ancillary trustee for real estate domiciled in other states, unless it is in the form of an LLC or partnership. At this time, I'd like to introduce my colleague, Michelle Shipp, Senior Trust Officer with Montecito Bank Trust Wealth Management.
Thank you, Susie, and thank you everybody for attending today. Although we can't see you on the webinar, we feel you in spirit, and we want you to know you can reach out to us at any time. My portion is to really just explore with you factors to consider when designating a trustee, which is a very personal decision. In order to carry out your wishes, select a trustee with the technical knowledge, the communication skills, and a platform for the delivery of your wishes. I'll highlight some of those factors and also mention a few, the benefit of a corporate trustee, what they might offer you. The very first thing for all trustees is to understand your intentions and being able to manage your assets. Your intentions are memorialized in a trust or a will. And it's very important that your trustee can understand reading those instruments and interpreting your wishes so that they can be fulfilled. The nature of your assets, there may be a range. It may be straightforward, or you may have complex assets that are specialty assets held in multiple states. If that's the case, you may want to ask yourself, does that trustee have the platform to manage and effectively administer those specialty assets? Another consideration is how long will your trust administration last? We often see trusts that are administered for multiple generations. If you name an individual as your trustee, they may pass away before the administration is complete. If that occurs, they may need to designate a successor trustee. And sometimes finding a willing successor trustee to serve can be challenging. The benefit of a corporate trustee is that they'll be able to continue administering your trust for the entire duration. This provides continuity of management. When looking for a trustee, also consider how their role is to coordinate among technical advisors. That includes estate planning attorneys, CPAs, and different asset managers. It also includes your agents for both financial decisions and healthcare decisions. And Jackie, thank you. I know your portion will cover a bit more on agency and those roles. But for example, just to illustrate how technical things can become, you'll have tax elections that will need to be made in coordination with a CPA. There's income tax, but there's also estate tax. And being able to understand the IRS requirements, you'll need a trustee who can coordinate with a CPA and have their guidance when making those important tax elections. As Susie mentioned earlier, that having a trustee that's impartial, someone who's objective, is vital to a good administration and fulfilling your wishes. It may be difficult for a family member to serve in that impartial trustee capacity, depending on the family dynamics. A corporate trustee or a licensed fiduciary would be an objective third party and would be an option to consider. Having an independent trustee is something that may help your family be relieved of that burden, but they definitely would be an important part of the process. For example, a trustee has to make decisions about discretionary distributions. And when those requests come along, we are governed by your trust or your will, and we're held to those, what your intentions are is our guide. So if discretionary requests come in and a family member is serving as trustee and has to maybe say that that's not a distribution they can make at that time, you can see how family dynamics and how interactions may be impacted. So an impartial trustee having a third party might be a way to preserve the family dynamic. The corporate trustee setting, just to give a few examples, the first thing I would say is talk with the different trustees that are available out there. Get a sense of how they work. Not all corporate trustees are the same. Not all licensed fiduciaries are the same. And it's important to get a sense of their style, their culture, and their operations. In my current role, we administer estate plans locally and administer here in town. We take a team approach. We have portfolio managers, trust officers, and a team of support. And in banking, there's often regulators that we're held accountable to, that we have very strict reporting requirements. This is, what makes us impartial, because we have to make sure that we're reporting appropriately within our banking system. And the sophisticated software that can be offered in a corporate setting and even licensed fiduciaries, we're gonna have the ability to provide reporting to your beneficiaries, which is very important to make sure the communication levels maintained and the accuracy of information is maintained. So final thoughts, this is a very personal decision. If something we talk about today comes up for you, you want to talk with us, reach out to any of us at any time. But do make an assessment of what your family dynamic is and how your intentions can be fulfilled so that you can plan now for peace of mind. And Jackie, I'd love to hand it off to you.
Thanks, Michelle and Suzi and Denise and Luke. Thank you everyone for attending this afternoon. So why do you need a licensed professional fiduciary or a corporate trustee? As Suzi and then Michelle pointed out, often if you name a family member, it can be a burden to them. For us, it's our job, it's what we do. We have all the tools at our hand, and we take kind of that family. I'm sorry about my phone. I tried to turn it off earlier, so hopefully that's not too disruptive. Anyway, as part of my presentation, I'm sort of going to give you some case studies that will maybe help you think through the process and think of why you may wish to consider a private professional fiduciary or corporate trustee. That's someone other than family or friends. So first, just let me briefly tell you that the California Licensed Professional Fiduciary licensed means we're licensed by the state of California, and it has been that way since 2008. We can act like the corporate trustee as trustees, executors, administrators, but unlike the corporate, we can also act as financial power of attorney and healthcare agent under healthcare directive. For my company, we have more than one fiduciary. If I were you sitting at home, I would wonder why I would want to name Jackie Quinn. I'm not getting any younger, as you may tell, or maybe my lighting's really good. But we have, in my company, we have several fiduciaries on staff. There's 4 of us all together, plus a support staff. And so we sort of have our built-in succession plan, if you will. And we currently manage over $100 million in assets, which I'm sorry, I have to stumble over. But so that's kind of our background. So why would you choose corporate or private fiduciary over your sweet little children, Bobby and Mary? Well, dad had just died several years previously. Mom's in her 80s, and Bobby was always the good son, did everything right, never did anything wrong, was so trustworthy. And then Mary wasn't so great. She was into trouble with drugs, had antagonistic relationships with her parents, etc. So the parents had named Bobby as the person to take over, Mr. Responsible. So fast forward maybe 10 more years, and mom is no longer capable of handling things, and Bobby takes over. Bobby proceeds to steal 4 properties from mom, finance his lifestyle. The quote unquote bad daughter Mary is trying to tell anybody who will listen this is going on, and no one believes her because she was so bad. In the meantime, Bobby was able to basically take 4 properties, have mom's house in foreclosure. We got the case literally as it was being sold on the courthouse steps, and were able to at least save her house for her. And after several years, move her safely to a facility, and she passed away at 97. But that's just one of many, many stories that should make you just give pause. I've been doing this for such a long time, first as a legal secretary, then paralegal, and then later as a fiduciary. And back in the 80s and early 90s, you know, the attorneys would point out that Mary and Bobby maybe don't get along. Maybe that's not a good idea to have them named. And almost to a person, they would say, we don't care, we'll be dead by the time they handle the trust or estate. Well, the reality, today's reality, people are living quite long and hopefully healthy lives. And so they may need this assistance, like my prior case that I just mentioned. And suddenly these children who really the parents never felt were capable of handling this are handling things for them. So again, it's just, I just want you to really give this some thought about your choices. One of my other kind of stories that I'll share today, and believe me, I have millions, is that there were a group of friends who were all the same age, and 2 of the women had been worked together for 30 years. They moved up to another city and lived next to each other. They were great friends by all accounts, and they both got kind of mild cognitive or stronger impairment at the same time. And what ended up happening was the granddaughter of one of the friends was quote unquote helping my client and helping herself to my client's funds, et cetera, et cetera. And so in this case, we had to go through court to get a professional fiduciary named. And I mentioned earlier that we can act as conservators. That's kind of the last option available to most people. And I'll just say that's kind of what happens when you haven't put a good estate plan in place. So that's just sort of my cautionary tale. We've also been brought in through the court. I have actually had a couple instances at the same time where family members have been named to administer the trust, and they just couldn't. They were just, it was overwhelming. The grief was overwhelming. Everything was overwhelming to the point of they didn't do anything towards administering the trust for several years. And it took another family member who was involved to sort of bring action to have that person removed and have a professional put in. There were several properties that could have been lost because property taxes weren't being paid. It just was kind of an incredible situation. And again, one that happens more than you would think. So I just keep saying that's sort of my cautionary tale about really think about who you are naming, and to make sure that you are doing it, as Suzi mentioned, while you still have the capacity to do so. Again, otherwise it can, potentially end up in a conservatorship. So as a power of attorney, we, as I mentioned, do it both for financial or healthcare. And often people have most of their assets in a trust, but there are assets that can't either be put in a trust, IRAs, for example, or just some other smaller assets, and a power of attorney is needed. So we mentioned that we do sometimes work with the corporate trustees. We will do this for clients that they have. We've also been hired to just sort of assist a beneficiary and a corporate trust department to sort of work together. Sometimes a beneficiary just doesn't understand the rules, and they're just mad at the corporate trust officer and think they don't like them. That's not the case, and we can help the beneficiary kind of approach the trust department and trust officer in the correct way, so that everybody can help, do what they are supposed to be doing. It allows the corporate trustee to be able to get the beneficiary what they're asking within reason. So that is just a kind of another service that we have. And where the healthcare agency comes into play sometimes can also be when it comes time to either be placed in a facility or bring in home care. These are all things that we can help with. And we also work with what we call care managers. We're care managers in a sense, but we like to bring in professional care managers for a couple of reasons. One, they cost less than we do, and they're so knowledgeable about all the aspects that need to be done to help with someone's care. So again, I just want to reiterate that we're not providing legal or tax advice. We also sort of do things in the way that the corporate trustees do, although they may do it more in-house, but we have a team, and typically we'll stay with whoever your financial advisor was, whoever your CPA was, if it makes sense to, and if we don't see obviously any problems. But we all work in conjunction to make sure we're doing the best that we can to either administer your trust or your estate after your death, or to make sure that everything is running smoothly and in your best interest while you're still amongst us. So that's, I guess, all I have. Oh, there was someone had mentioned to me, and actually Suzi did address it. If somebody happens to name us a private professional fiduciary as their trustee and then they move out of state, we can still act on their behalf. In fact, I have 2 or 3 currently right now who've moved out of state, and we can still act for them. So anyway, thank you for this opportunity, and I know we're open for questions. Or Denise, I think you wanted to speak first, sorry.
So you were sharing some stories, and I would also like to do that because I've seen a lot over the years, as all of you have as well. So, and these are family and friends that I'm going to talk about. One of my best friends, her parents were well into their 90s and still living. Mother had dementia, father did not. They were they sold their house, went into assisted living, but 90-something father was helping his wife as a caretaker, especially during this time in COVID when they were short-staffed at all the assisted livings. He had actually named his daughter as successor, my friend, as successor, trustee, executor, healthcare agent, the whole shebang, and not his son. He actually told his son, which most don't even do, and he told his son that he trusted the daughter more to do it, which of course exacerbated the rift that already existed between the siblings. The daughter, who was self-employed, spent the better part of 2 or 3 years on a daily basis helping her parents, managing the multiple issues, especially that arose during COVID, trying to deal with her mother's dementia and what to do and the money. And her father just recently passed away. She is settling the estate. She did everything without help from the brother who lived in a different city. She's deeply resentful that she actually couldn't work. She couldn't earn a living the last couple of years because this was a full-time job. And I'm sure you guys have encountered this time and again. And this was not anticipated in advance, I think, by the parents, who just assumed this is the way things are done. And she is trying to settle the estate now with accountants, not knowing that there was even a step up in basis, involved. So, and these are capable people who it's a big burden on the family, as you said. I see time and again that people don't understand the difference between a healthcare power of attorney and a financial power of attorney, and therefore can't assess the skill sets that those roles would entail. I actually had worked for a healthcare company, and it surprised me no end when one day I was passing out some advanced directive forms around the office for people to fill out. And one of the colleagues said, "Oh yeah, my father told us what he wanted, but we don't agree and we're not going to do it." And I was shocked that they hadn't had that conversation. So people will often appoint an agent, either tell them, often not even tell them they're the agent, but even if they do, they don't sit and have the conversation about what is exactly expected. Does the person actually want to play that role, and what the alternatives are? There is no comprehensive discussion that takes place because I don't think they know how to start that conversation very often. And then I have my very best friend who's in a lawsuit with her brother right now. Her parents, also elderly, lived into their 90s, were in assisted living, sold the house, while still their own trustees of the trust. The mother eventually turned it over to the daughter to be successor trustee, had originally named both children, daughter and son, as co-trustees. The son had had a stroke and got removed, daughter sole trustee. Because my friend was settling two estates back to back, her uncle's, her mother's, has children at home, and was still working during the first estate settlement as a college professor. Slow in distributing assets. Her brother's wife and the brother filed a lawsuit. So now two attorneys are involved. So the mother, who didn't want to spend the money for a private fiduciary, though we had recommended it given already existing tension, now both parties have lawyers and they're going to spend even more. So these are some of the stories as to why we wanted to present this subject today. From listening to the three of you, I think there's a couple of best practice tips we can highlight real quickly. Jackie, you said it's important to do this while you still have capacity, because once you're deemed not to have capacity, and the longer we live, the more likely the odds are that dementia will afflict many of us. Yeah.
Yes, and one thing I didn't mention is, for those of you who already have estate plans, it's always a good idea to revisit them. You know, maybe every 5 years even, you know, tax laws change, lots of things change. You may forget who you even named to be your successor trustee. You know, sometimes people name someone, and as Denise mentioned, the person doesn't even know. And suddenly they have this huge responsibility. So it's just important to look at all the options that there are for you out there, and to just carefully plan. And the other reason is, you know, as we age, sadly, we do start getting a bit of diminished capacity. Legal capacity is slightly different than what we call regular capacity. But again, I would advise you to speak with your estate planning attorney if you have one. If you don't, the museum, as they mentioned, has a list. I'm sure any of us could also provide you with some recommendations. But it's very important. And it's amazing how many people just sort of ignore it. I mean, even myself, who is in this industry, I just updated my plan, and it hadn't been updated since 2007. So lots have changed, and I know better. And so I'm just not calling anyone out, to say, please take a look at what you've done. Really give it some thought. These are important decisions that you're making.
So definitely the periodic review, whether you want to put that on a certain schedule, or definitely anytime there's a major life event, perhaps a birth, a death, those are triggers to go back and look at your documents, who you've appointed. Have you appointed the right agent for the right job? You were talking about some of the various roles, you know, you can have different agents in different roles, and look at it with that different lens, and don't succumb to the knee-jerk reaction, as so many do. I'm going to name the child closest to me. I'm going to name the child that visits me the most. I'm going to name the oldest child. You know, really look at this from a different angle of who is suited, willing, able, you know, capable. Do they understand what you want? Do they agree to abide by that? Have you named a backup? Have you safeguarded and shared your documents? I mean, have you given the agents a copy? Do people know where to find these important documents? You know, healthcare agent is so important in case you're rushed to the hospital and you don't have family members ransacking the house. I in a different Lunch and Learn, I shared the story of my dear cousin Ron, who passed away last year. He had redone his trust and will, didn't give a copy to anybody, but told us all who the new trustee was going to be, successor trustee. No one could find the documents after he passed away. The lawyer had apparently passed away, and a copy didn't get sent anywhere and couldn't be found. They had to go to a 22-year-old will that appointed his sister, who he didn't even speak to anymore, as executor, with no knowledge of what to do. She was in a different state. She had to basically hire an attorney to do everything and eat up money in the estate. These are, you know, all the little things to make sure that your wishes are met, and ease of administration. So do any of you have other best practice tips to share before we go to questions?
I'd like to comment, Denise, and I think everyone on the panel has echoed this. The most important thing is to think seriously about what you want to accomplish, either for your loved ones or for charity, or for a combination of the two. well in advance while you still have capacity, and then to share that information with the people or institution that may be most involved in carrying out your wishes. So it's really a great process to start thinking about, particularly after the fire and the debris flow and COVID. It's just time to think about it. And as Jackie mentioned, some of the documents are out of date. As you mentioned, Denise, an out of date document can have unintended consequences. So while you're calm and able to think through these things, I think that's the best advice anybody can get. And then how you accomplish that could be through a corporate trustee or private fiduciary, or a family member or friend who is connected in some way, either as a co-trustee or as an advisor. That's a very common form these days of keeping a personal approach along with a corporate or professional approach, making sure that your wishes are carried out.
Can you speak a little bit more to how you work, how you collaborate with a family member that's appointed?
Sure. Jackie, I think maybe has a different approach from the one that we do, but as corporate trustees, very often a family member will be named as a co-trustee. And in essence, the corporate trustee has all the liability, but many families feel more comfortable thinking that they are including a family member as a person who can support the needs of the other beneficiaries while still fulfilling the terms of the trust. Corporate fiduciaries literally work under the terms of the trust, what the trust says, not somebody's opinion, not somebody's request for an early distribution, not some other misunderstanding, but corporate fiduciaries literally go by the terms of the trust. In many cases, we see the trusts way ahead of time, many years in advance, and we keep the trusts in an electronic file. It's a totally confidential file. It's electronic. There's no paper floating around. There's no lack of confidentiality. Sometimes that gives us an opportunity to read the trusts ahead of time to make sure that the trusts have been prepared by qualified estate planning attorneys and that the terms of the trust can actually be fulfilled. Michelle, you might want to comment a little bit on that because I know you've read many, many documents.
It's a great point, Suzi. Reviewing the documents, but making sure they're clear, making sure there's not ambiguity that may be unintended, could be resolved now. If not resolved now, what the trustee will be left with is consulting the drafting attorney. And if there's still uncertainty, you may even have to go to court and request further guidance so that your intentions can be fulfilled. So I would say the best practice is get very clean documents drafted with your estate planning attorney so that there's no ambiguity and that your intentions can be clear. Jackie, did you have any thoughts?
I was just going to add that you guys are saying corporate trustee, but any trustee, right, any professional. So we try to always review the documents in advance. Sometimes we get surprised and aren't told that we've been nominated. That's always fun. But it makes a lot more sense if you're doing this planning to kind of include certainly all the professionals that you need to in what you were doing. So
yeah,
that's it. I see we have some questions too.
We do, but can you talk a little bit about the difference between a healthcare power of attorney and a financial power of attorney?
Sure, it's exactly as it sounds. Financial is just dealing with financial assets. As I mentioned, not everything, if you have a trust, is able to be placed in the trust. So financial power of attorney, you can help with that, but that is only while someone is alive. It doesn't usually carry on after someone's death. And then the healthcare, it's often known as advanced healthcare directive. It's exactly what it's saying. You are making healthcare decisions for others. And for us, if we're named, we sort of have a process that we go through to question the person naming us to find out, what does it mean, pull the plug? Does that mean nothing? Or does that mean, you know, after a certain time of treatment, then pull the plug? Same for feeding tube. Oh, I don't want a feeding tube. Well, what if the feeding tube could help you for a month and then you're better? So we try to get as definitive as we can. And then just circling back to working with family, we as professional fiduciaries are not named as co-trustees with family. Our malpractice insurance heavily frowns on that. That doesn't mean we don't consider the opinions of the family members. But as I like to say, we're the ultimate decider, if you will.
So I think we do have some questions. Shall we go to them? And we are sharing contact information for everybody participating today. Did we have a screenshot to put up? I know you were given a handout with that information earlier.
Hey, and we have some great questions. Here is one. Should you have both a will and a trust, or is just a trust enough?
I'm sorry, I couldn't hear you. I just lost where the chat questions are.
Jackie, the question was, should you just have a trust or should you always have a will and a trust? As Jackie pointed out, the trust takes care of the assets that are actually held in trust. The will actually gathers up other assets. Sometimes it's called a pour over will, that gathers up assets that couldn't get into the trust and either distributes them in a different way or contributes them to the trust for distribution under the terms of the trust. So some people only have a will. We generally recommend a trust, particularly because it can be managed during your lifetime as opposed to after death, which is what a will does. But almost all qualified estate planning attorneys, I'm certain, who create trusts also create these pour over wills that are an adjunct. And then they also consider the financial and healthcare powers of attorney as well.
Wonderful, thank you. Okay, here's one. My estate plan is over 100 pages. What part should I share with my trustees?
I'll take that one. So the heart of the plan is usually who are you naming as your successors. Then there's the dispositive provisions. Who are you leaving your money to and how? And then if like sometimes a special needs trust can be created within the trust or another type of trust. You look for that, and then people want to see the powers that you're granting to the trustee. So those are kind of the key things. And then of course, signature pages and asset list if available. I think those are kind of the key pages that you should share. But I don't know, Suzi or Michelle, if you have anything to add.
Again, depending on who you're looking to designate as trustee, they may have their own requirements. If you're asking for someone to serve as trustee, you may want to let them know there are 100 pages governing what their trust administration duties are. So it's a good question. It's a long document. But if you want someone to step in and serve fully, they should understand from page 1 to page 100 what those duties would include. Suzi, your thoughts?
I agree, and it's possible that the 100 pages may include some amendments that have been added over time. And generally, when you get 2, 3, or 4 amendments, it makes a lot more sense. Most attorneys recommend doing something called a restatement of trust that allows you to discuss new terms and conditions, even different beneficiaries, but it doesn't require you to retitle your assets. So that's what a restatement does. So if it's a very long document and it has many, many amendments where you have to track them forward and then backward and then forward and then backward to find out what was really intended, very often attorneys recommend doing a restatement. I don't know if that answers your question about the 100 pages, but that could be one reason.
And also, I'm sorry, I can't hear the questions and I just read it. So I thought you were asking who you should share it with, if you like a bank or something. So yes, if you're sharing it with a trustee, they need to see the whole document.
Here is a question. I currently have an institutional trustee. Question for Jackie. What advantages might there be to having a private fiduciary?
Well, so as we outlined, there's a couple of differences between us, and the rest are pretty similar. One could be the fee structure. Again, everybody's a little bit different. And then just for the professional fiduciary, the fact that we have the component of the personal kind of care and the, again, financial power of attorney is the difference. And it doesn't mean a corporate trustee, I'm assuming you guys can hire care managers or whatever, I'm not really sure, but that's, to me, is sort of the main difference, is that we have sort of that thing that's not available for corporate.
And one name a fiduciary as a backup to a family member named as trustee.
Yes, the document can list a series of successor trustees, and those can be individuals, private fiduciaries, or corporate trustees. And in that list, it leaves an opportunity for certain ones of those people or institutions that are named to decline to serve when the time comes. The assets may be of such a small size or so complex that it would be difficult to administer the trust under its terms. So a corporate trustee or a private fiduciary that has already been named might decline to serve. So it'd be good to have a backup that you've thought about ahead of time, just in case those circumstances require someone to decline to serve at that time.
Or vice versa, Suzi, right? Where they name a family member and name a corporate trustee or a private as
Correct.
the backup in case that family member resigns or is unable to serve.
Correct.
And I would just add that you can designate successors. However, they may, as you said, not be willing to serve, where that can be tricky to find a successor trustee who's willing to serve if the original trustee did not administer it in a way that they were comfortable to then step in and take over. So just keep that in mind. I would say the best practice is really find the right trustee up front. So hopefully you don't have to go to a successor, but yes, you can name, as Suzi mentioned, different successor trustees.
Thank you. Okay, here's one. Are the designations trustee, fiduciary, executor interchangeable? How is a private fiduciary compensated?
Okay, so it's confusing for folks who kind of aren't in what I call our world. We just think everyone knows what these terms mean. So if you think of fiduciary as the sort of umbrella term, and then underneath that term, there are all these other terms: trustee, administrator, executor, agents under power of attorney. So fiduciary is the very broad term. So often someone says, yes, I have a fiduciary, and somebody goes, what does that mean? It means you've named someone, either corporate or private, to act on your behalf in those various roles. And then as for compensation, again, I just briefly touched on it. We're all a bit different. We have a scale at our office where there's hourly charges, and it's, again, depends upon the person doing it. We have several fiduciaries, as I mentioned, and then we have support staff. And that, if you think of it, we call it above the line, if you saw our fee schedule, and then below it is the percentage based on the asset value. And one of our clients just recently said it's the above above the ground price and the below the ground price. So if you think of it, say, for example, if someone did need our assistance while they were still living, we just have hourly rates for that. And then Suzi or Michelle, I'll let you guys respond.
Our fee schedule as a corporate trustee is a percentage on an annual basis of the assets under management that are held in the name of the trust. And then there are potentially separate executor fees for different assets that may be outside if we're also named as the executor or as the administrator of an estate. And so the fee schedule we set is based on assets under management or assets under responsibility. Different from an hourly rate. For the most part, we don't have any hourly rates at all, but we do have some separate rates on real estate transactions and that sort of thing. And we are more than happy to provide our fee schedule to anyone who might want to see it. And that's easy to compare with the private fiduciary fee schedule for what you might be considering in the way of successor trustees.
Okay, we've got one. If a family member is the primary agent for an advanced healthcare directive, but the estate finances are under the control of a corporate trustee, how do the two work together to find and fund assisted living arrangements?
Well, I can comment on if a corporate trustee is managing the assets, the terms of the trust will determine how much of that income or how much of the overall value can be distributed and for what purpose. The terms of the trust determine that. So if Jackie or a private fiduciary is working with someone to find an assisted living facility, then that other professional, Jackie in this case, would let us know what is being requested from the trust, and the trust terms itself will actually, or themselves will actually determine what's available to support that person in assisted living or elsewhere.
Okay, what do our panelists think? Should we answer one more? Okay, let's see. How do I know what to charge for the time it takes to administer my aunt's will after her death?
If you're talking about a will, it's actually a legal probate fee that she will be paid. And that's, Michelle, you might want to comment on this, but the court will decide what you're going to be entitled to.
That's right. And even, Jackie, I'm sure you've seen in the probate courts, a careful review of what those trustee fees might be submitted to the court. They may or may not approve them. And I think trustee fees are governed under reasonableness based on the circumstances and obviously the probate code, as you mentioned. So, there definitely is oversight for what can be charged, and the probate court may or may not approve them.
The state of California does have a threshold, though, under which you do not have to go to probate court. So let's say most of your assets are in a trust, only a few assets are outside of that trust, and you have a pour over will that deals with those, then you can very often avoid going to probate court. I have had the great joy of settling 2 estates for family members, my dear mother-in-law and my own parents, completely unpaid. And I wouldn't advise it to most people. It was extremely time consuming, as anyone who's ever done it will tell you.
Okay, and I would just like to quickly say we will get to unanswered questions. I will share these with our speakers, and perhaps they can answer them via email.
So thank you so much, everyone, for your interest in this topic today. We thought it was timely. And we hope that some of today's nuggets will help you look at things a little differently and help you make decisions that are appropriate for your own needs. As always, we encourage you to discuss everything with your professional advisors. You are free to reach out with more questions to any of us, and you do have that contact information. I believe you were also given a few other additional resources that include links to some advanced healthcare directives that you can download and use. I would like to quickly mention that the Museum of Natural History will be hosting a more comprehensive estate planning workshop this November 14th, which is a Sunday afternoon at 3 o'clock. We're hoping to host that in person at the newly remodeled Fleischman Auditorium, though it will also be taped. These workshops delve a little bit more into various estate planning topics. We're going to have an attorney, a CPA, a professional fiduciary, and a retired plan giving professional that are going to address it from many angles. And like I said, a little more comprehensive content. Even if you feel that you've completed your estate plan, it's always beneficial to hear from these professionals about the elements that work together to ensure that your wishes are fulfilled and how some of the new laws might be impacting your planning. So this was our third Lunch and Learn of this year. We look forward to continuing the program next year. We're already starting to talk about some topics for next year, which might include a digital estate plan and your retirement accounts and the impact of new laws on how you might want to address them. If you have other ideas or there are topics you'd like to hear about, please contact Sarah. She's the one who sent you the email link for today's program, and we'd love to hear. Again, thank you for your support and for today. And with that, I'd like to thank our speakers again and hope to see you next time.